Chapter 6, and hopefully my voice isn't getting too hoarse since this is the fourth video I've done today, since I had to redo both 5 and 6 because I wasn't smart enough to make sure my microphone was on. And yes, I just looked down at my microphone to make sure it was on. So, onward. Chapter 6 I've always liked. I like talking about the Constitution. I think we should know more about the Constitution. I'm glad you guys are getting a little exposure to this, and I hope when we're done, you know more about the Constitution than you knew going in, unless, of course, you were already really up to speed on things in the Constitution. I find it extremely important that it's obviously the basis for all of our law in the United States and how we run things. Unbelievable, right? That it's still the oldest constitutional document that's still in continuous use. It's it. It's the framework. It is the thing upon which all our other laws are based and held. It's the standard to which they're held, right? When the Supreme Court looks at laws, the one job is to determine whether or not that law meets the constitutional standard or not. Okay, and that's a difficult job because things do change. I think one of those issues I'll talk about maybe a little bit even as we go along, how obviously things have changed. Our Constitution was written 250 years ago about, and they didn't have the internet back then. They didn't even have radio back then. So times have definitely changed, and yet our Constitution is held up rather well. I believe your book says 3 key concepts, and it would be those 3: the separation of powers, the supremacy clause, and the contract clause. And I think, and I don't know if I added this one or if it was added by the book for the PowerPoint, but the commerce clause is also a huge concept, and maybe it was left out this chapter because we talk about it later. There is one question on the test about the Commerce Clause, so here's the answer. The Commerce Clause is very broadly defined. Okay, it's very, very broadly defined. There, now we can get on with the other stuff. So the separation of powers, right? So it's one of the genius ideas, I guess, of our forefathers was that we would have 3 main branches of government, but we also have levels of government. Right, so we have both a horizontal separation of powers and a vertical separation of powers. So you have to remember vertical's up and down, and horizontal is side to side. I remember that by remembering a song by the Bellamy Brothers. It's just a vertical expression of horizontal desire. There might be a little sexual innuendo in there. Anyhow, so the federalism part of the separation is their separate and distinct roles, the levels of government, right? So we've got the federal, state, and local governments that all make different laws, right? And there's a separation of powers there, but there's also a separation of powers at the federal level, and most states, too, between the executive, legislative, and judicial branches. The Supremacy Clause, of course, says that the Constitution itself it's the supreme law, right? All laws made are ultimately held up to that standard as to whether or not they are constitutional and can be reviewed by the Supreme Court in that regard. But federal law does preempt state law in those cases where it's constitutionally able to do so. And it's said to preempt, right? State law can be invalid for conflicting with federal law. Now, one question oftentimes comes up, though, is why are states allowed to make additional laws? Let's look at environmental protection, for example. We're pretty normal here in Montana. We kind of often just go by what the federal government says, but as you know, California sets a lot higher standard for different things, and so states are allowed to go further. Oftentimes the federal law is simply the minimum. The contract clause says the states cannot pass laws that impact rights and duties under existing contracts. The federal government can. Okay, the federal government can embargo a nation and agree not to send them, or decide not to send them wheat or other products that we might produce, maybe sensitive electronics or those types of things. And they might decide to do that for, political security reasons, whatever the case may be. And so they're exempt from the contract clause, but states aren't. A state couldn't decide to, the contract clause anyhow, I was thinking about this example earlier where, we, and there's probably contracts that the railroad has and the state has and some of the businesses in our state have to transport coal through the ports on the West Coast. And it's been in the news that some of those ports would like to shut down that coal shipment. Shipping coal that goes overseas to China and places in Asia and whatnot. And they'd like to shut it down for, supposedly environmental reasons. Well, I'm sure that the contract clause would be used to argue that, as long as those contracts were in place, right? Well, states could still pass a law that would say, hey, when the contract's done, we're not going to allow any more coal to be shipped out of this port. Okay, but they might not be able to, and I don't know. I mean, I'm just making an example here. They might not be able to pass a law then that would impair those contracts prior to, the contract expiration. And certainly may not apply in emergencies. So earthquakes, natural disasters, anything like that, states may pass some laws then that would impair contracts. Just because they have to, maybe for safety and soundness reasons, or protect people. Commerce clause, just briefly again, they're going to have the power the federal government's going to have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Again, it's very broadly interpreted, and I'm going to skip through the commerce clause because there's only that one question on the test. The rest of it is on a later chapter. State taxations under the Commerce Clause as well. So do the protections of the Bill of Rights apply to businesses? Well, yeah, for the most part. Certain rights that can't really apply to businesses. I mean, we can jail people that are working within a business for wrongs that the business did, maybe, but some of those protections to the people wouldn't apply to businesses just because they can't apply to a inanimate object, I guess. But things like, for example, the Citizens United decision, which we'll talk about again in a little bit, certainly granted free speech rights to corporations, and so certainly corporations do have some Bill of Rights protection. So they're not absolute, and probably the best description ever of this, one of the Supreme Court justices years ago, Thurgood Marshall, I believe, said, we have freedom of speech and we love it. He didn't say all this, but I'll get to his part in a little bit and I'll paraphrase it. But we love freedom of speech and we all appreciate that. It's a right that we need to protect dearly, but that doesn't mean that somebody should be allowed to yell fire in a crowded theater when in fact there's no fire. The result may be a melee that might cause damage and harm to people, right? And so we have to be really careful in how we would restrict those rights, but there do have to be some restrictions. And for the most part, we don't restrict it on the front end, right? There isn't really any prior restraint. We don't restrict it on the front end. They're allowed to yell fire, but they're going to be held accountable for it in those cases. But for the most part, we defend our rights of free speech pretty rigorously. Pretty vigorously, I should say. Got to balance it with public policy, as we said. It removes issues from the political process. So that's what the Bill of Rights does. One of the reasons the Constitution passed was because some of those states insisted that the Bill of Rights be included, because Bill of Rights are really limitations on the federal government's power, right? But it can vary during emergencies. And think back to the internment, and most of us would say it was wrong. Probably all of us would say it was wrong. The internment of Japanese Americans in World War II, right? certainly that was a violation of their rights. It probably wouldn't be tolerated today, but it was a different time then, right? So the First Amendment is the rights, freedom of religion, press, speech, assembly. Note, and this is on the test, that press, or publishers, right, are the only industry that are actually granted specific protection under the Constitution. Some might say, well, guns, no, gun ownership is a protected right, but not the industry, whereas the press or publishers are specifically, granted this power, this freedom under the First Amendment. Speech and assembly we talked about. Right to petition for redress, one that often gets kind of overlooked, and yet it's extremely important. It's one that we take for granted, but it's certainly not universal around the world. That is, a right to really sue our own government. How many places around the world do people have that right? I don't know if they do in Russia or China or Indonesia or India. I don't know. They might, but there's a lot of places that don't. Okay, you sue your government, they probably laugh at you, I guess. And yet here in the United States, we kind of take that for granted. First Amendment, freedom of religion. Certainly. These words are not in the First Amendment. There is no separation of church and state in the First Amendment. The First Amendment says Congress makes no law establishing a religion nor prohibit the free exercise thereof. Paraphrased, but pretty close. Okay, and so those are the clauses that are in there affecting religion, right? And has to deal with carrying on to employment discrimination, which we talk about quite a bit later, but we can't discriminate based on religion, okay, in employment situations, unless it's one of those, maybe a rare case where it's a bona fide occupational qualification. Freedom of speech, right? There is unprotected speech, and that's kind of what we talked about, right? Fighting words, or words that would cause damage or do cause damage, or words that incite violence. I think we've got coming up next. Those types of things wouldn't be protected certainly after the fact, right? We can all say them, okay, but they might not be protected if they actually cause or could have caused these types of incidents. Defamation also. What's defamation? Well, that's when you say something about somebody that causes harm. If it's untruthful about somebody, you're spreading lies, rumors, vicious rumors, whatever the case may be about somebody, and it causes that person harm. Okay, economical, emotional, those types of harms. Okay, that can be considered defamation. And certain obscenities, we do govern that a little bit. We govern that on TV, and what can be said and what can't be said, or what's supposed to be not said, those types of things, right? Quote, give me a chance to get a drink of water while you guys read that. So symbolic speech is protected too, right? Right to protest, the hold signs, hand gestures, those types of things, right? They're protected. Now the overbreadth doctrine is the right to challenge a law, though not directly affected by the law. And interesting, there's a group called Judicial Watch, right? And they're the ones that have been responsible for suing the State Department for the Freedom of Information Act to receive documents that they deem should be public, and in this case, a lot of these are related to the Clinton emails, etc. It's not really have a direct effect on Judicial Watch, okay, but they have the right under the overbreadth doctrine to do that. This gets back to that, remember the standing to sue? Okay, this is an exception to that standing to sue rule that it takes to get into court, okay? In certain circumstances, you can sue, okay, challenge a law or a rule, okay, even though you're not directly affected by it. colleges are setting up, some of them are setting up safe zones, right, where people can go to be free from conversation or words that they might find, I don't know, reprehensible, or they might find them to be offensive, right? And if I or somebody, while not directly affected by it, you could still sue the college for setting up something like that. I don't know whether you'd win or not, but you could sue the college and say, you can't have that. People don't have a right to in a public place, a public institution. They don't have the right to set up barriers that prohibit free speech. It'd be interesting to see, and there probably will be cases like that. This whole safe zone thing is fairly new. I did like the president of the University of Chicago wrote a letter to incoming freshmen and said, there aren't any safe zones at the University of Chicago. Expect to be exposed to many of the same things that you're going to get exposed to in real life. We're not going to pamper you, and it was, I thought, a great letter. But that's my opinion. Commercial speech, right? We are protected. And the recent high court ruling jumped down here was Citizens United. Okay, it's a huge ruling, and it gave corporations it didn't give them that right, but it protected their right to spend money on elections and those types of things. And there was a kind of an uproar about the Citizens United decision. There was even people, Republicans and conservatives, some of them said, maybe there is too much money involved in politics and whatnot. And that could be, but I've been thinking about it, especially lately, because I was one of those even. I thought, maybe there's too much money. Maybe they shouldn't spend that. But as I've watched some of the, like, for example, the IRS targeting certain groups, and other agencies of the government targeting or going after things, I got thinking, maybe that's the offset, that corporations, with money can spend money to maybe protect our rights. I don't know if that'll ultimately be an offset to that, but it could be. That's number one. Number two, I don't think there'd ever be anything stopping a big corporation from buying or starting their own publication, in which case they would be kind of granted free speech rights, or free press rights. So I don't know. When I look at the ruling now, I think it was probably the right decision. But anyhow, that protected corporations, gave them the free speech rights. Freedom of press. Our forefathers said, hey, there needs to be an organized scrutiny of government. There needs to be. I was thinking about this, and again, back to the Constitution, we put this in the forms of the press, but lately it hasn't been the press, and I wonder what our forefathers would think about this. The exposure of our government, I don't know, dalliances into the crazy side. I think they've been exposed by, like, hackers. You got, like, WikiLeaks, and you've got with Julian Assange, and you've got Edward Snowden, and you've got some of these other Guccifer, or whatever the heck his name is. You've got these hackers and whatnot that have exposed some things that most of us would consider crappy, that a lot of us anyhow would consider crappy that our government's been doing. And that it's the same thing really as the press from 100 years ago, although you would argue that the press wouldn't be able to do those things through illegal means, though they sometimes did. It's kind of similar, and I wonder if our forefathers would want these people to have maybe some of those protections. I don't know. Again, they're not absolute. There are some prior restraints, and that gets back into the maybe the obscenities and different things like that our press is kind of prohibited from, but not a bunch. Defamation, of course, obscenities and defamation, yeah. And actual malice towards a public figure. So you can print truisms or even opinions and whatnot, but actual malice towards a public figure might get you in trouble. Second Amendment, We hold that near and dear here in the state of Montana. We don't worry too much about local state laws that might restrict our ownership. We worry more about federal laws. I don't think too many gun control laws would go very far at our in our legislature, but you never know. Right to possess arms, there hasn't been many high court. There's been lots of lower court opinions, but not that many high court. Heller and McDonald, I think one was Chicago and one was Washington, D.C. I think McDonald was Chicago and Heller was in Washington, D.C. in two different cases. Similar in that they did go to the Supreme Court, and in both cases, the Supreme Court ruled on the side of gun owners, we would say. It was a narrow opinion, meaning that it really dealt just with that case, and it basically said that the city or state law, I think in both cases city laws, from Washington, D.C. for sure, had gone too far in restricting the gun ownership. Didn't set any guidelines, didn't say what's not far enough, said no, we're going to keep tackling those in court. But they said those specific laws went too far, and I think they had to do with just even owning handguns. I think basically in both cases they kind of wanted to ban handguns in homes by homeowners. So that was it. There's going to be other cases that go to the Supreme Court, obviously. Increased litigation, I don't know. I haven't really seen what I would think is increased litigation in terms of gun rights. Certainly, since 2008, we've seen a huge increase in the number of guns being purchased. A completely separate issue there. So the Fifth Amendment, we've all heard people say they take the Fifth, meaning that they refuse to testify because it may incriminate themselves. Okay, and the Fifth Amendment sets forth due process. Okay, we have due process rights. The Miranda rights, for example. You're entitled to an attorney. Anything you can say can and will be used against you in a court of law and things like that. And they're required to go through these things, and they're required to accumulate evidence in legal and proper ways. And searches and seizures is a different amendment. I'm sorry, but it's a huge protection, right? The Fifth Amendment's also kind of odd because it also says eminent domain, but eminent domain and due process kind of go together. What that means, eminent domain is the right of the government to take, for lack of a better word, take property from individuals, okay, for public use. Okay, but I put this as expanding because the definition of public use has expanded. We all would imagine that, if they need to build a road, yeah, that's understandable. Okay, if you got to build a road or a highway, something like that. What about power lines? To get power to people. Well, yeah, okay, that makes sense. But what about a pipeline, like they're fighting about over in North Dakota? Should government have right for eminent domain there? Well, I don't know, maybe. We got to get that fuel to places where it's needed, don't we? And and so it becomes really a question of where do you stop, where do you start, and where do you stop in terms of public use. And it's gone so far now that in many cases the government has allowed property to be taken and allowed cities or states then to resell that property to people for commercial use. Maybe just to improve an area or build a shopping center or, get Walmart to town, whatever the case may be, right? One thing hasn't changed, and that is that property owners, if their property is taken, are entitled to just compensation, fair compensation. And the 14th Amendment has to do with due process, too. So the 14th and the 5th oftentimes go together quite a bit. We talk about the procedural, the proper notice and hearing for criminal offenses, those types of things. Substantive right, property rights affected by government action. Fifth Amendment, the 14th Amendment. What that means is that the 14th Amendment said that the Fifth Amendment and these other rules and whatnot are incorporated are brought over to the state and local governments. In other words, if your offense is a state or local offense, you're still entitled to your Fifth Amendment rights. Okay, it's not just, you're not just protected in a federal court, you're protected whether it's state or local in terms of the Fifth Amendment rights. And that's in the 14th Amendment, then it's called the incorporation document because of that. Minimum rationality and equal protection, I guess. And your book does a fine job really kind of giving you some examples of that at the bottom of page 189. I'd look those over, and it just says that, you know, when we're considering whether or not we ought to allow discrimination, you know, and you know, if we look at quasi-strict first, it kind of says gender. Well, what's that mean? Well, you know, can we have men's and women's basketball teams at the college? Well, yeah, absolutely, you know. It's kind of discrimination, though, isn't it? I mean, to have different ones instead of different ones, it is, but that's okay. You know, we've said that that's okay. It doesn't require a lot of scrutiny. Some of that may carry over to certain jobs we've had in the past, or it has, and some of these barriers are breaking down to the roles of women in the military, for example. And you know, 30 years ago, women were absolutely not in any combat roles and were far behind the lines and whatnot. If there was conflict going on, might have to go back to 50 years ago to Vietnam, but you know, those roles are slowly changing, but still, you know, they're allowed to maybe still, you know, disqualify women for certain roles in the military. Okay? Minimum rationality says, you know, we can have some age standards maybe where safety is important, right? Yeah, you know, airline pilots, maybe they should be retired before they're 89 years old. Okay, things like that. What do we got? Height, weight, testing. Those things are all okay if they're applicable to the job. Okay, so we can put those types of standards in if they're applicable to the job. And then strict scrutiny is there has to be a compelling state purpose. And I think about that in terms of maybe kind of what's been going on lately with the refugees and immigrants from the Middle East. And there's been some proposals maybe to subject them to increased vetting. Okay, to vetting that exceeds what we might have or require for other refugees and immigrants. You know, that's definitely a discrimination. You know, we're definitely saying, yeah, absolutely, we're going to discriminate those people, but does it meet a compelling state purpose? You know, with the terrorism and such that's going on, might it be considered that? I don't know. It'd be a tough one, I would think, for the courts to try to decide. So, equal protection issues, we deal with many of these. Legislative apportionment, a lot of the jury makeup. A student just sent me a nice little audio kind of about jury makeup and how those things are. It's interesting. There's, you know, the court case there, Supreme Court case, wasn't all that old. I think from the 80s, where it talked about whether or not you could discriminate when you're going through the jury selection process and you get to eliminate, or there's challenges for cause, and then there's forget the other term, but basically each side gets to eliminate a certain number of jurors or potential jurors, and so what happens if you went through and eliminated all of them that were minorities? If the numbers were right, you could do that. Or if all your choices to eliminate were minorities, you know, it's interesting, right? Voting requirements, that's been in the news. Welfare residency, you know, who's qualified to receive it, immigrants, etc., rights of aliens, you know, ability to go to schools and medical care and those types of things. Property tax to finance schools, that's been pretty widely upheld. I don't think there's a lot on here. I'm not going to ask you questions in this test about probably any of these things at all. We'll eventually talk a lot about the Fair Labor Standards Act when we get to labor relations. So, by what authority do government entities impose regulations? By the authority granted to it by the legislature and ultimately the Constitution. Is there any limit to the extent regulations impact our lives? It doesn't seem like it, you know, and more it seems like regulations are becoming more and more of a burden even on individuals. How can an individual or business organization challenge regulatory authorities? You know, we'll talk about administrative law in a later chapter and how you go about doing that. You know, most people take a semi-direct route and call their legislator, their congressperson, and complain about it. That's it, folks. Oh, I'm just over 30. Sorry. I'll get out of here.